So, good afternoon, everybody. I think we're jumping in on a bit of a surprise. We didn't even did any warning posts to tell you we're doing this. Um, but we thought lockdown level 2 regulations, it took us a good day to just get over the trauma of slightly more onerous regulations than we expected. And then Bruno said, we need to quickly talk about this. So good afternoon, everybody. And hi, Bruno. Thanks for your good
Hi.
idea to quickly do this.
We were just getting a lot of questions, especially people that read the regulations themselves. They're not very sure what it means. So I suppose it's just worth just getting out there, briefly explaining. We can go into detail over the next coming days or weeks, but just going out there and saying, listen, guys, don't stress. I think it's the panic that I'm worried about.
Yes, and I'm glad we're doing this. I recorded yesterday with TPN just to quickly explain, and you were busy answering questions as well. So what we've decided to do is today we're just going to touch on Regulation 54, 53, dealing with evictions and rental housing, because the regulations are pretty clear on where we are in level 2. And then we're going to leave it to you guys to read through the regulations. We are going to post the regulations for you as well in PDF format. And then you can watch this quick video where we just discuss it quickly. Please then post your questions. And then tomorrow evening on the Wednesday webinar at 6 tomorrow evening live, we will then deal with the questions coming out of the regulations. So I actually think it's pretty perfect. So this is basically the please post your questions post, except not in a post format, but in a video format. So have fun. Bruno, okay, I'm going to throw it over to you. The questions that we're obviously getting is, can we do evictions? And obviously we've been saying all along, guys, we've been doing evictions. There hasn't been a prohibition on evictions per se. We've obtained eviction orders. SSLR has, for Mark and partners, you have, everybody's obtained eviction orders. What did the new regulations change? What's happening in Regulation 53?
Well, look, from my perception of the regulation is they've just taken a more comprehensive approach on how to actually manage evictions during the state of disaster. They could have actually probably done this beforehand, but I think what they were trying to do is they were trying to introduce less limitations, but governing it a bit more. So the same way that they did with alcohol, where now it's like it's allowed, but there's a whole range of things that, obstacles or hurdles people need to overcome in order to be able to do it. It seems that they're doing the same with the eviction. So from my perception of it is for starters, they outlawed just general evictions, kicking people out, but that's without court orders, right? So that's the first thing that we need to mention. When you start reading it, it's not to say that no evictions can take place. Evictions could always take place, but court orders were always supposed to be there. And that hasn't changed. So now they've been a bit more specific on the evictions that they don't want to allow at all. And then short of that, they say that the court may grant certain suspensions in certain circumstances. So they qualify, they almost qualify the court's powers as to when and how the court is supposed to deal with these evictions and what circumstances they need to look at. And I mean, you'll probably touch on how this kind of relates to PI. It's almost like throwing a whole bunch of new requirements into like PI, into the legislation that governs the way that we do evictions. I suppose from my part, if I had to pick one thing that I think is very relevant and that I know you're going to touch on because it's something you've been speaking about quite often, is this principle of Ubuntu, but specifically now when we look at the way that they've actually codified it. And they've taken the principle, they've put it into the regulations and said, okay, now everyone's got an obligation to be nice, to try and negotiate, to speak to each other, try and come up with payment arrangements, how and when people are going to move out. And the court is going to consider this a factor. So whereas in the past, for example, I'm owner, you're not, doesn't matter what happened in the lease agreement, but it's not there anymore, you need to get out. The courts now seem to be, or rather government seems to be leaning or trying to almost govern a situation where there could be alternatives, and they'd rather that we explore the alternatives than approach court and render people homeless. And that's, I think, the primary concern is we don't want people on the street. So if somebody's sitting at a 7,000 Rand property and they can afford to move to a 3,000 Rand property, I don't think the court's not going to grant the order. I think you'll get that eviction order relatively easily, executable right now. The execution will not be suspended until the end of the state of disaster, if the person's not going to be rendered homeless. There is a risk, however, with homelessness that the order would be granted but suspended. I don't know if you share that sentiment.
I share the sentiment. What I really like this. I like the fact that we're bringing in Ubuntu, actually in a true legislative nature. I think the way it's done, unfortunately, is potentially less ideal, because the moment you force people to be nice, they're not nice. I mean, nobody's ever been this panicky about, oh my goodness, I do not have enough wine, until there was a ban. I won't even lie. I'll admit that the moment Cyril said on Saturday it's uplifted, I was like, okay, cool, that's it. You will not catch me again. So I am stocked up. I'm ready for another alcohol ban. But don't call me if you run out of wine. This is up to you now. But the one, using the wine example, is everybody during full lockdown, when we discussed things like the rent deferment agreement, deposit utilization agreements, the conversations has always been, be nice, consider the other party, see where we should go. The moment something is legislated, human nature dictates that now suddenly you're going to say no, 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 no. Very important is we have to come to the party and talk to each other. So I almost want to beg people not to, just because it's a requirement in the regulations, please use your rebellion on whatever else, but not this. Because the reason for this is we need to find a way to meet each other halfway. Landlords are suffering, tenants are suffering. We need to find middle ground. And last night I drafted an agreement for TPN, part of the rent deferment agreement, an agreement to vacate. So this is something important to discuss, and I'll post a link to my video recording with Peter Mennen from TPN as well as a link to the rent recovery pack, because it's free of charge. You don't even record data or anything, you just download and use it. But I think it's important to note, Bruno, that we know in terms of the Prevention of Illegal Evictions Act, even if you do have an agreement like that in place, you still can't just use that to kick somebody out, even after all of this. This is just a way to record your settlement agreement. So because the regulations now require landlords and tenants to enter into negotiations, to find each other halfway, maybe just make sure that you record it. These documents are available for free. Just record it properly. If it's a bit more intense and legal technical, go to an attorney. But I think even more so now, Bruno, and I'm seriously not saying this as a gay property law alliance thing, but now it's always been an expert specialist field. Evictions has never been a general practice field, but I think even more so because you, me, and Greg actually joined us. Unfortunately, I had to pop out to a meeting, but Greg joined us on the conversation before this. And the discussions we were having was the content of Regulation 53(2) A2, where does it go, A2I? That is not far different from what we are used to when we're dealing with the Prevention of Illegal Evictions Act. We need to bring certain things to the court's attention. And now more so than ever before, you need to get to a specialist firm for your eviction. The reason for this is if you do not plead the right things, so if you do not ask the right things, and if you do not tell the court exactly what they need to hear to be able to authorize your eviction to be executed still in lockdown level 2, you are definitely going to run into problems. So it's a very important thing to be aware of. The regulations doesn't limit us from doing evictions. We can still proceed. Like I said earlier, we have been doing evictions even in lockdown level 3. Just to put you in the picture a little bit there, the eviction orders that we've obtained in lockdown level 3 was most of the time granted with a proviso that the sheriff can only attend to the eviction. With one of our orders, well, a few of the orders was 5 days after the end of lockdown. I think we lost Bruno there, but I'll carry on. And if he rejoins, I know he had network problems. I'm sorry, Bruno, but I told you I'll catch the ball. So if the order is that you had to execute, the tenant had to vacate, illegal occupant had to vacate, but he didn't, we can only send the sheriff to attend to the execution of that order within 5 days from the end of lockdown level 3. So that's going to be next week. A few of our other orders was only 90 days after the end of lockdown level 3. So it's very important to be aware of this. We can execute on those orders, but the difference now in the lockdown level 2 regulations is that it's not stayed. It's not stayed or suspended until the end of lockdown level 2, but until the end of the national state of disaster. Nobody knows when that's going to be. So my suggestion at this stage is, if you have an eviction, make sure you go to an expert attorney, because otherwise you're going to be stuck with an eviction order that can only be executed at the end of lockdown level 3. Oh, yay, Bruno, I think we have you back. So it's very important to notice.
Sorry.
Yay! No worries.
Sorry about that.
Oh, I had it. I didn't even lie to anybody or anything. Didn't swear nothing. So I was just confirming that we need to, eviction orders, if you do not do it right, it can be stayed until the end of the national state of disaster, which is going to be who knows when. Even if you do it right, there will be orders that is stayed, because remember, the court's order is in the court's discretion, and the judge or the magistrate that you draw is the one that's going to make this call. So, but we can do evictions, but we just need to comply with a few extra things, so just a few more hurdles to get over, but it's not really a crisis in any way. No, on evictions, anything that you still want to add, Bruno?
Well, I don't know if you actually touched on this. You probably did, but it's so interesting. So, like, even our PI legislation has a whole bunch of things that the courts will consider. But over the years, you'll see that the cases and the courts have placed more and more of a burden or emphasis on requiring us as attorneys on behalf of the owners or persons in charge to make sure that that information is actually acquirable. So we will now send letters asking for certain information. So we can say in the papers that we've asked and we haven't received cooperation. We make mention about us knowing whether the house is occupied by certain people or not others. And we almost need to disclose everything to the court so that the court knows that some level of due diligence has been done. And with something, my gut tells me this is going to be very similar. The courts are almost going to say, well, you guys know how to deal with PI and all the requirements there. So here's a bunch of new stuff. Just kind of chuck it in there in your checklist and go down the list and make sure that you've spoken to your clients about the possibility of negotiating. Now mention in the eviction application that you tried and you weren't successful. So it's not just good enough, in my opinion, to now launch the application and later go, oh, but we tried. The courts are almost going to request it, because even though it's there and the courts are supposed to request it without us necessarily making mention of it, we know that the courts are going to require us to aver it, because we're going to expect the opponents to come back and submit proof that yes, we did comply, or no, we didn't. So it is rather specialized, and I mean, it's very similar to labor processes insofar as the negotiation is concerned. Very similar things happen there. That's why you try and make it procedural and try to take these ethics and these good morals and good practices and put it within a framework that's definable. And we do that in labor very well, especially when it comes to retrenchments and things. And I think now with evictions, we are going to need to make sure that, you know, we develop the correct framework. So when we go to court, it's silver platter, look at everything we've done. So we don't get bad judgments. So we don't get bad reported judgments or bad decisions that require us to wait 4 months, because we don't know exactly what Selma said. State of disaster could be until next year. And now you have a bad judgment where the magistrate didn't apply his mind. I'd rather hand it to him in a silver platter and go, this is why I'm asking for what I'm asking. So give me this order. Even if I need to come back to court to ask again, give me the opportunity. Don't just make an order that's going to screw me until next year.
Yes, yeah, exactly. What I find interesting, Bruno, is Regulation 54 dealing with rental housing and allowing the Rental Housing Tribunal to now hear spoliation applications on an urgent basis. So spoliation, just to take everybody through it again quickly, this is deprivation of possession. So the examples here would be lockouts, changing the locks, taking off the front door for maintenance, that's spoliation, guys. Disconnecting utility supply, water, electricity, whatever, all the clever plans, moving people in with other people. You're not allowed to do it anyway. It's nothing new. It's not the regulations that's limiting us from doing that. It's never been a thing. You've never been allowed to do that. But now the regulations allow the Rental Housing Tribunal to hear these matters on an urgent basis, to be in the tribunal in 24 hours. Now, part of the regulations now require the Minister of Human Settlements, Lindiwe Sisulu, to give us directives on how the tribunals should function. So I think that's actually pretty cool, because it's been in limbo, how long it's going to take to get those directives, and how effective it's going to be, and whether it's going to work or not. I think time can only tell, but it is what it is. What I do think is actually pretty cool is it does compel the landlord and the tenant both to enter into negotiations and to find a way to meet each other halfway. So very important on this is failure to do so by the landlord and the tenant is now classified as an unfair practice in terms of the regulations, then in terms of the unfair practice regulations to the Rental Housing Act. So this is crucial. So that tenant that's been refusing to negotiate with the landlord, now his failure to do that is an unfair practice. I think it's going to open the door for a lot of other things, Bruno, but you know, my positivity levels are so flippin' high. We all just look at me and wonder, oh, shame, does she ever know what's actually going on in life? So I know there's a lot of critique on this particular part of the regulations. I'm saying let's wait and see. It doesn't serve us in any way to spend hours and hours on preempting a negative outcome. Let's wait and see. Let's wait and see what happens. But in the meantime, I think it's crucial for people to realize you are now required to enter into negotiations, to open the door. I think my advice to landlords is open the door. Get that email out today. Open the door for conversation to say, Mr. Tenant, I'm so sorry. I cannot allow you to pay a reduced rental anymore. I've lost my job. I'm taking a reduced payment. I can't meet my financial obligations in terms of this property if you don't pay your rent. Things like that. Put it in writing, get it out. So when we need to do an eviction, we have the proof that you have done everything in your power to try and settle the matter. I think that's the only thing we can do, right, Bruno?
Absolutely. Get everything in writing. I know that face-to-face communication's great, but just make sure that everything that you do is always recorded in some form of email at some point.
Yes. And I think that's the joy about things like Zoom or Teams or whatever. All your online virtual conversations can be recorded. And I think that's it. That's genius. I mean, if you negotiate with the tenant, it's pretty much face to face. But you can record it, and those are things that we can use at a later stage. So keep that in mind. And I think my suggestion is take the time, read through the regulations, but calmly. I'll admit this, I wasn't ready for this. I was there where I thought level 2 regulations. I got this Gazette yesterday, and I opened this Gazette and I thought it's just going to say, "So now you can have wine again," eh? And it's not what it said. It wasn't about me, it turns out. Who knew, Bruno? But it's much more onerous than what we expected. So be calm, read through it, and then please post your questions, and we will jump on tomorrow. If there's a lot of questions, don't stress. I think I can at least sneak in 15 more minutes for the Wednesday webinar if we have to. But please bring your questions, because if we were that long in lockdown level 3, I think we're going to stay in lockdown level 2 for a long time. I'm not, don't mean to jinx anything, but I think it's worth our while to really spend time on knowing the regulations. And please feel free to post your questions. Otherwise, we are going to be bored tomorrow evening and have nothing to say. Anything else from your side, Bruno?
No, I'm good. I'm more worried about my internet connection here. Vodacom's not doing me any favors today. But no, I think I'm good. Yeah, but by tomorrow night we should have a whole bunch of questions, and in one day a lot happens.
Yes.
So it should be a very interesting conversation. And the nice thing with people asking questions is they think of contingencies or perspectives that maybe we didn't. So maybe there's something in here that we just haven't picked up. So yeah, please, as many as possible, and we'll try to get through as many as possible.
Brilliant. The only thing I want to add, I'm just thinking about that, is the short-term rentals. That's now completely allowed. So Airbnb, all the short-term rentals allowed, but with a proviso that you limited to 50% floor space. So this is one of the conversations I think we need to get in first tomorrow evening. What does this mean practically? How does this change your life for the Airbnb investors? What does this look like? So I think we're going to start there. I am going to wrap this up. I know Bruno is struggling with his internet connection, but guys, please have a read through, post your questions. We will be on tomorrow evening at 6 to deal with all your questions. In the meantime, please keep it. Please post your questions so we can deal with it tomorrow evening. And today is extremely cold, I think, across the country. So please stay warm and stay safe. And then we will see you guys tomorrow evening.
Cool. Awesome.
See you tomorrow, Bruno.
Great. Cheers.
Cheers. Bye-bye.